Hey guys, welcome to our video. Hope you're having a fantastic day. This is John Watts. We're going to look at just part of a recent opinion for two reasons. One, I want us to see just very briefly about a law called the Fair Credit Billing Act. But more importantly, I want you to see an argument that is often made by credit bureaus, but even more so by furnishers. So a furnisher is somebody who supplies or furnishes information to a credit bureau. In this case, it's Chase Bank. And I want you to see their kind of bizarre statute of limitation argument and what the court rightly does with this. And this is a case out of the Southern District of Florida just last month, January 25th, 2020. And so let's look at the facts here. We have the plaintiff who was a victim of identity theft. It was a former employee, stole her identity, opened up some accounts. Pretty unusual. That employee was arrested and was convicted, and the state attorney, and I think even the judge issued an order, wrote a letter, basically saying, look, this plaintiff, this is not her debt, and she should not be responsible for it. And we'll see that the credit bureaus and the credit card companies, the furnishers here, just ignored that. So ultimately what happened is she ends up suing Chase. This is down here in the lower green. She sued Chase, Capital One Bank, Equifax, Experian, TransUnion for violating the Fair Credit Billing Act, the Fair Credit Reporting Act, and then the Florida version of the FDCPA, which applies to original creditors. And if we go back up to this yellow section, we see that she has disputed this a number of times. We've got August 25th, 2016, August 31st, 2016, she gets a response. She sends more disputes September 2016, again, several in September, March 2017, August 2017, September 2018, November 2018. And she's doing all that. And in part because of all these disputes, we have this just really goofy statute of limitation argument by Chase. So let's look at, just for a moment, Fair Credit Billing Act. So this is helpful to know what you have to do in order to have a claim under the Fair Credit Billing Act. And basically, the Fair Credit Billing Act is where you get a credit card statement, you see an error in it, you properly notify the credit card company in writing, and then they do not take the steps that they need to take. And so three elements the court describes for us here: existence of a billing error, so you have to have that. And then the plaintiff, the consumer, has to have a timely written notification of the billing error. And then number three, a failure of the credit card issuer to comply with the requirements of Section 1666. Now, if there's any interest in this, I'll do a more detailed video on exactly what the Fair Credit Billing Act is, but I just want you to see that. But here's the real part of the case, is Fair Credit Reporting Act. So at this point in the case, everybody has settled or otherwise been dismissed, but I assume they've settled. I'll tell you this, it's very unusual for companies to not immediately get rid of accounts that we say are identity theft. And when they don't do that, those are tremendously valuable lawsuits. So I suspect that the other companies were willing to pay the price to get out of this, but not Chase. And so look at Chase's argument up here in the yellow. It's a statute of limitations has run, and you cannot sue under Section 1681 S2A. Now, if you saw the video from yesterday, that's the Hinkle versus Midland credit case. We talked a lot about Section 1681 S2B, but this is S2A. So here's the first argument, statute of limitation. So you have to sue not later than the earlier of 2 years after date of discovery or 5 years after date of violation. And they agree it's a 2-year that applies. The lawsuit was filed April 10, 2019. So she had to discover her violations before April 10 or April 10, 2017. So anything before that would be barred by the statute of limitation. So statute of limitation is a period of time that you have to sue. And then the plaintiff says, well, you're liable under Section 1681 S2B. And so we'll come back to that. So here in green is Chase's argument. They say, look, when you discovered that we failed to properly investigate one of your disputes, and then more than 2 years goes by, you can never sue us for this ever again. And so here's how they calculate. They say Chase failed to complete a reasonable investigation no later than October 2nd. So the dispute was August 25th. Equifax has 5 business days to notify. Chase has 30 days to conduct an investigation. Accordingly, Chase argues plaintiff had until no later than October 2nd, 2018 to file suit, but she only filed suit April 10, 2019. So it's too late. Nothing you can do. You can never challenge the false credit reporting on your credit report. That's the position that this massive, major national bank called Chase Bank is taking. Absolutely absurd, ridiculous, stupid argument. But we see this. I mean, I first dealt with this probably 12, 13 years ago. And when I saw it, I said, that's the stupidest argument I've seen. And the judge pretty much said the same thing. But you can see these companies will still continue to make these arguments. So here's the plaintiff's position. No, I brought it within 2 years statute of limitation because you violated the section multiple times, not just in 2016. So you failed to conduct reasonable investigations December 2018, January, February 2019, and then we got these other dates. And each of those disputes were in response to separate violations of the FCRA because each publication of plaintiff's credit report was inaccurate and ongoing, and Chase was required to investigate the new information provided in each of her disputes. Well, Chase says, well, if you're allowed to do this, you can just continuously file disputes and perpetually restart statute of limitation. And I think the court is very generous here. This is not really accurate. District courts are not really split on this. There are a few outlier decisions that just make no sense that say once 2 years goes by, then no matter how many times you dispute it, you can never sue. That is a very bizarre thing. So here's one. Holding multiple disputes cannot continuously restart statute of limitations clock. But the majority of courts adopt plaintiff's position. Here's a really dominant case. It's from Northern District of Georgia, Thomas versus Wells Fargo. And let's see what the judge says here. S2B, we're going to come back to S2A in just a minute, but S2B, that's the section that says you can sue a furnisher if they do a lousy investigation after they're notified of your dispute by the credit bureau. Creates a new right of action each time the furnisher of information receives notice of dispute from a consumer reporting agency. Furnishers are thus required to investigate anew, even if they previously investigated. And it must follow that any new violation of this duty creates a new right of action with its own limitations period. So here's what I want you to think about. If I run a red light and hit you, and I'm negligent, which I would be negligent, in Alabama, you have 2 years to file that lawsuit. Let's say you don't file the lawsuit. But then 2 years and 2 months after I hit you again. I damage you again. I injure you again. Now, how stupid would it be for me to come in court and go, hey, you know what? I can crash into this person as many times as I want, and they can never sue me again because they didn't sue me after the first time I crashed into them. I mean, the judge would look at me like I was the dumbest lawyer around. And I would be if I made that argument. But that's what these banks make when you sue them under the Fair Credit Reporting Act. So defendant argues plaintiff's formulation would result in a perpetual statute of limitation. This court disagrees. It remains that furnishers can only be sued for violations and be liable for damages caused by violations that occur within 2 years prior to suit. So a judge gives us an example. If the furnisher on January 1, 2018 fails to properly resolve claim of false information, then the furnisher will definitively and forever be safe from any suit by January 2nd, 2020. So more than 2 years has expired. The furnisher will only face new exposure if, based on new disputes, it yet again fails to appropriately respond. And in that circumstance, any damages would be limited to what occurred within the new period. The court says, so that's not perpetual. But look at this, what we haven't read. Defendant's formulation, it's defendant's formulation that creates a perverse result. Furnishers would essentially be forever immunized for failing to address any new or ongoing disputes regarding a report item, so long as 2 years have passed from the first time it failed to retract that item. Such a result is contrary and simply makes no sense. That's absolutely right. And so the judge in Florida, just in January of this year, says, surveying the case law, considering the consumer protection purpose of the statute, and analyzing the plain language of Section 1681 S2B, court is more persuaded by logic than the Thomas Court and many others that found each failure to conduct a reasonable investigation in response to a dispute is a separate FCRA violation subject to its own statute of limitations. So this is, I bring this up, one, so you'll know the answer to this, but two, to see sometimes in the law things are not so clear cut. In other words, somebody may say, well, I've got a case that says X. Well, okay, I'm sure you do. But it may be completely just off the charts wrong, okay? So I see plaintiffs do this sometimes. And there'll be 50 cases going one way and one case going their way. And they go, see, this is the absolute truth. Probably not. But then we see companies do the same thing. And particularly if you don't have a lawyer or you have a lawyer that's not real experienced, they'll bring out these cases even though they know all these other decisions are against them. And frankly, they have a duty to disclose that, but they don't. They just slap this one sort of crazy case and go, see, you got to drop your lawsuit. You have no claim. We're going to sanction you if you pursue this. And it's just kind of part of the hazing process that these companies go through. So one last thing here. Chase also argued plaintiff concedes to the extent plaintiff's FCRA claim is premised on 1681 S2A, required duty to provide accurate information. There's no private right of action. Here's what that says. 1681 S2A, when you read it, it's fantastic. I mean, it talks about the furnisher has an obligation to only report accurately, and if they report something that's inaccurate or that they know is inaccurate, then they have violated the Fair Credit Reporting Act. And that's true. And people see that, they go, this is why I can sue the furnisher without doing a dispute first. The problem is only the government can enforce that. You have no private cause of action. And I can't tell you how many lawyers and consumers I've had this conversation with. They go, well, that's unfair. It says it in the law that they cannot do this false credit reporting. I'm like, I know. But you have to read the whole law. You have to interpret it together. And you have no claim under 1681 S2A. So just remember that. If you want to sue the furnisher, you've got to do a dispute through the credit bureau. That triggers the obligation under 1681 S2B. Now, if the furnisher is a debt collector and the FDCPA, Fair Debt Collection Practices Act, applies, then you may want to sue under that instead of doing a dispute. I will say this, in general, if you just sue directly under the FDCPA, that case is worth, X number of dollars. If you do a dispute under the Fair Credit Reporting Act and they verify it, then in my experience, that case maybe is worth 4 times, 5 times what it would have been worth had you just sued directly under the FDCPA. So maybe we have a debt collector reporting something that's incorrect and we say, if we just sue them, they got to come in pretty quickly, pay 10 grand. But if we do a dispute and it does not get fixed, in other words, that debt collector was warned, it had an opportunity to fix it, and it said, nah, I'm not going to fix it. We're going to keep that false information there. Well, instead of being $10,000, that case, maybe if they settle it quickly, is $40,000 or $50,000 or $60,000. So there is an advantage to disputing it. And now there are times where it's better to just go ahead and sue for a variety of reasons, but just want you to keep all that in mind. So we're not going to look at the rest of this case, talk about under the FCCPA and then some state law stuff. But hopefully this was helpful to you, and I will put the link to this, assuming it's on Google Scholar. If I don't find it, you can find it because it may pop up later. But this Milgram versus Chase Bank And this is the Southern District of Florida, January 25th, 2020. So thanks for watching this, and let me know what you have an interest in, or if there are any cases in particular you want me to go through, if you find this helpful. And if you need anything, if it's kind of a private nature, reach out to us directly, alabamaconsumer.com or 205-879-2447. But it's just kind of a general question. Feel free to put that under the comments, and I'll talk to you guys later. Thanks. Bye-bye.